I got picked up on the warrant, which actually caused me to lose my job.
So the defendant's aware there's a bench warrant out for his arrest.
All right. Mr. Stokes, I don't know if you heard that.
You have a monthly child support obligation of $72 and that you're currently behind in the payment of that support in the amount of $7,961.10.
We have 3 cases in this video.
I'm Chris Stokes.
All right. So we have called your matter, sir. You have filed a motion regarding parenting time. Is that correct?
Yes, sir.
And what is it that you are seeking?
To see the kids.
Well, see the kids is a very broad definition. So are you seeking, what type of parenting time are you seeking, sir?
I guess weekends and holidays, the standard parenting time. I'm sorry.
Okay, no problem. Ms. Barber, what is your position regarding standard parenting time for Mr. Stokes?
I honestly do not feel comfortable with my boys seeing him at the moment. He hasn't seen them in 2 years.
So what we got is 2 different options. One option is the parties can go to mediation and see it and have discussions and see if they can figure out a plan and or a schedule, or we can set the matter for an evidentiary hearing and the parties can make their arguments and then the court would make a recommended schedule. Mr. Stokes, what are your thoughts?
It hasn't been 2 years since I've seen the boys. I guess my main reasoning for all this is, unfortunately, they are in what would be an unsafe environment.
Okay, so Mr. Stokes, my question was, do you want to try mediation or should we just set this matter for a court hearing?
Probably just set it for a court hearing.
All right, so if Mr. Stokes doesn't want to participate in mediation, then that's what we will do. We got to decide if we got to decide what type of time we need to get this done, if we need an hour or if we need more than an hour. Mr. Stokes, do you intend to hire an attorney or represent yourself?
An attorney. If she's willing to do mediation, I'm more than happy to come to an agreement with her.
All right, Ms. Barber, what are your thoughts on having a mediation where the 2 of you talk with the mediator present to see if you can reach any type of agreement?
I mean, we can try it to see what happens. That's totally fine with me.
The mediation gives the 2 of you a lot of control over the situation because the 2 of you can talk about, numerous things as far as the schedule goes, starting slow and then increasing time if things are comfortable. You can agree to have a schedule and then go back to mediation to see how it's working. So it gives the 2 of you a lot of control and say, more so than I think when you have the court simply grant and say what the custody is going to be. So if you both are willing to participate, then I would refer this matter to mediation. They would reach out to you, schedule a mediation date, see if you reach an agreement. Obviously, if you don't reach an agreement, you still have your right then to come back for a hearing. So Mr. Stokes, are you willing to do that?
Yeah.
And Ms. Barber, are you willing to do that?
Yeah. Now, is that an in-person?
I think they are still doing that by Zoom also.
Okay. That would be ideal.
Okay.
But yeah, I really, honestly, I just don't, gosh, it's been so long. It scares me for them to go there, but yeah, absolutely. I'll participate.
All right. Well, those are things, like I said, you can certainly discuss that at the mediation. And then if it makes sense to make small steps before the bigger steps, then that's something the 2 of you can discuss at mediation too.
Okay.
All right. So we will refer this matter to mediation. Thank you both for appearing and you may sign off.
Your Honor.
Yes, sir.
So the defendant's aware there's a bench warrant out for his arrest.
All right. Mr. Stokes, I don't know if you heard that.
Yeah, I've been paying on that actually.
Okay.
It's for child support.
All right. Thank you. All right. Thank you both for appearing and you may sign off.
All right, thank you.
Mr. Rhodey and Ms. Asquith.
Ms. Asquith, if you'd state your name for the record, please.
Mr. Asquith.
Cameron Rohde.
This is a matter of Cameron Rhodey versus Kira Asquith. Parties in this case have an order modifying modifying child custody, parenting time, and referring the case to friend of the court for child support signed August 21st, 2012, which orders Mr. Rhodey to contribute child support and medical support for 1 child in the amount of $215 per month. There's been prior enforcement on the case. The current balance owed is $10,299.17, of which $8,299.82 is owed to Miss Asquith in child support. The state is owed $1,008.09, and then there are fees and costs. Mr. Rhodey was making payments for income withholding the past year. In June of this year, current plus arrearages were applied to the account. In July, we received $75.06 through withholding. And then there were no further payments until October of this year, in which he paid a $500 bond from a previous payment plan.
All right, Mr. Rhodey, so what's been going on?
I lost my job in July, and then I just started going back to work actually in October. I got picked up on the warrant, which actually caused me to lose my job temporarily with that company. And I actually just started back with that company almost a week ago now. This week's my first paycheck back with the company, and that's been about that.
All right, so you have the ability to pay child support this time, correct?
At this time, yes. This Friday will be the first payment again on it.
Okay, thank you. So Ms. Mullen, does that mean he's currently on a payment plan?
No, it expired, and then following the arrest on this last fail to comply warrant. But I don't think we have the current employment or the return to employment information for withholding established again.
Where are you working, sir?
Bowler Aerospace?
Is that a place where you can get an income withholding order in?
Yes, sir.
Okay.
Actually, I just called yesterday about actually trying to get that information so I can give it to them.
Okay, excellent. Ms. Asquith, anything you'd like to say?
Nope. I mean, this year he did help out with buying Jared's school clothes and some school supplies and stuff at the beginning of the school year, so he did contribute that, so.
Okay, good. All right, it sounds like we're back on track. I mean, I know the arrears is pretty high, but with the income withholding order, I'm comfortable, I guess, sort of using this hearing as a warning, because I don't feel the need to make a contempt finding. It sounds like you're helping out, and if we keep steady payments coming in, sir, we don't have to do the payment plan. Okay, so I'm willing to work with you on that, but I want to adjourn this out 90 days. And if we're not seeing steady payments, either with the income withholding order or otherwise, it sounds like it works if we have a payment plan. So this is just kind of sounds like you're back on track. I'm willing to work with you on that because I just want to see steady payments coming in. Okay.
All right.
Okay. So thank you, sir.
Thank you.
Kristen Margaret Singleton versus Scott Brian Kinsey. We are here today for a hearing on an order to show cause. We are proceeding today by video conference. Miss, you are Kristen Margaret Singleton?
Yes, Your Honor.
Ms. Singleton, it states here that you have a monthly child support obligation of $72 and that you're currently behind in the payment of that support in the amount of $7,961.10. Do you understand that?
I do, Your Honor. Could I say something, please?
I need to ask you some questions first to make sure that you understand what your rights are. And if you want to talk after that, you're welcome to, but I've got to ask you some questions first.
Okay, Your Honor.
Do you understand that it's a crime to fail to pay child support to the very best of your ability up to the amount ordered?
Yes, Your Honor.
Do you understand that if you were to plead guilty to that offense, that I could sentence you to jail for up to 30 days?
Yes, Your Honor.
Do you want to be represented by an attorney?
Yes, Your Honor.
Do you have the ability to pay for your own attorney?
I do not, Your Honor.
So I'm going to put you in a breakout session with Ms. Underwood from the Public Defender's Office.
Okay.
We have Ms. Singleton and Ms. Underwood back from the breakout session. Ms. Underwood, do you know how Ms. Singleton would like to proceed?
Your Honor, Ms. Singleton, I believe, is the full-time caretaker of 3 young children. She does not have a job at this moment, but she is in school and taking her exam and looking for work. She has dropped off 2 years worth of taxes at H&R Block on Friday, Your Honor. She hopes to hear back before the end of the week on how much they will be able to take out for this arrearage. She hopes it would pay a substantial portion of it off. We would ask for a 1-week adjournment on this matter, Your Honor, to allow Ms. Singleton to provide the court with proof that she has filed her taxes, that they are going to be giving her a substantial amount towards this arrearage, Your Honor. And she is looking for work. Hopefully we can have some input on that by next Monday as well.
All right, I'm going to adjourn this to March 11th, so that's 2 weeks at 8 a.m.
Thank you, Your Honor.
That is going to be the only adjournment in this case. If there, the last payment, according to the information I've got, is back in 2022, and there's a almost $8,000 arrearage. So we either need to have something moving forward, or I'm going to set it for trial at the next hearing.
Thank you, Your Honor.
Thank you.
All right. Thank you, Ms. Singleton. You can go ahead and log out.
Have a good day, Your Honor.